Good afternoon, everybody. My name is Josh Gupta-Kagan. I'm a professor at the University of South Carolina School of Law in famously hot Columbia, South Carolina. And welcome to America's Hidden Foster System, bringing family separations without due process to light. We'll start by letting my co-panelists, Diane Redleaf, Andrew Brown, and Heidi Redlich-Epstein introduce themselves, and then we'll begin.
Good afternoon for most of you. I'm happy to be here and very excited that we're able to talk about this topic. I work on policy issues with United Family Advocates and through a private consulting a firm called Family Defense Consulting. As you'll hear, I've been working on this topic for about 21 years. So I'm very excited to be here today.
Good afternoon. My name is Andrew Brown. I have the privilege of overseeing child and family policy at the Texas Public Policy Foundation down here in Austin, Texas. I've been in this field for a number of years and have had the privilege of working closely with both Josh and Diane for many of those years, and really excited about the conversation and to have the opportunity to interact with you all a little bit later on.
Thank you. And finally, I'm Heidi Redlich-Epstein. I am the Director of Kinship Policy and State Projects at the ABA Center on Children and Law, and I will be serving as a moderator today as the focus is hidden foster care and the impact on parents and families. So I'm going to turn it over to Josh. I think, Josh, would you like to launch our first poll?
Sure.
Do do that? Okay, great.
Yeah, let's do that.
All right. So I am going to launch a poll. If people can humor me and participate, that would be great. And I'm also going to ask that you, if possible, put your questions into questions boxes, because as moderator, I'm going to be looking at those questions and fielding them for the presenters. But if you put them in chat, I may miss them. So if we could use questions, that would be great. All right. So I'm seeing one vote so far.
While the votes start pouring in, hopefully start pouring in, I'm going to set a few of the goals that we have as a panel for today. So first, we want to define what we mean by the hidden foster care system. We want to describe a little bit about why CPS agencies use this practice instead of the more formal system that we all know. I want to describe the harms and also the benefits of families confronted with a choice of using what we're calling hidden foster care versus the formal system. And then at the end, towards the end of my presentation, and Diane will form a part of that presentation, we're going to shift into a moderated discussion of what family defenders can do, both in individual cases in the courtroom when you get a case that you discover has a hidden foster care history to it, and also as a policy matter in order to regulate this system much better. Heidi, do we have results on our poll?
Looks like with the question, do you feel that you're familiar with and understand what is meant by the term hidden foster care? We have 21% yes, I've heard of it, 24% yes, I've experienced it, and 54% no, this is news to me, tell me more. So with that, we will tell you more.
Excellent. So I hope the 46% that didn't say no, tell me more, won't be too bored by the next couple of minutes. So here's what we mean by the hidden foster care system. So we're going to start with, how is this like the foster care system that we're all familiar with? What we mean by hidden foster care happens when a CPS agency comes into a family's home and says the parent and the child need to be separated. They got to do it now. They do it through, they effectuate some kind of separation by using state power. And they usually end up putting the child with a kinship caregiver. And then it's not entirely clear what happens. And as in the formal system, lots of things can happen. And I'm going to break down each of those points a little bit more. This is typically effectuated through something called safety plans, or different jurisdictions have different bureaucratic names for them. They're usually a document with not that much legal import, kind of presented as sort of a contract between the CPS agency and the parent. CPS says there's got to be some kind of parent-child separation, right? That frequently means the child goes to live somewhere else, usually again with a kinship caregiver. It can also mean a parent leave. So there have been plenty of cases where the CPS says, okay, we suspect you of doing something bad, so you, mom or dad, need to leave the home. Maybe someone else comes in. Maybe if it's two adults in the home, the other adult remains with the child, but somehow changing the day-to-day life of the child, right? So we're having a change in at least physical custody of the child. It can take place during an investigation. Sometimes CPS agencies will say, like, look, this has to happen until we learn more. Think about what that means for the burden of proof. Sometimes it happens after an investigation. CPS says, okay, we've substantiated. We think something bad happened and something's got to give. And we think that means, you have to go or the child has to move somewhere else. Importantly, on their own, this process that I'm describing doesn't change legal custody. A safety plan doesn't change legal custody, or safety plan by another name in another jurisdiction doesn't change legal custody. It can change where the child lives day to day, but not who is lawfully in charge of the child. There are some jurisdictions, this plays out differently in different places, like so much in our field. There are some jurisdictions that will tell parents or tell kinship caregivers, you should go to probate court, or you should go to whatever court, whatever family court, where someone other than a parent can get legal custody from a parent. So it can be related to a legal custody change, but in and of itself, legal custody usually does not shift. The agency uses state power to effectuate this change. Dorothy Roberts was referring to the threat of state action to induce compliance from families on the receiving end of that state action. And that's exactly what happens here. In the materials, Andrew put up a Texas form, which is a little softer than the South Carolina form. It's softer in the sense that the Texas agency was smart enough to say may, as in, if you don't do what we say, we may go to court and try to get your child removed. In South Carolina, they're slightly more direct. If the parent refuses, if you won't do what we say, then an out-of-home placement must be sought by law enforcement or an ex parte order, et cetera. We're going to remove your kid, right? Through the threat of removal, they're trying to induce the parent to say, yes, okay, I will allow my child to go live with a kinship caregiver. This is effectuating a change in where the child lives through an exercise of state power. Right? Where does the child go? They go to live with a kinship caregiver. Nationally, that's common in the formal foster care system. About a third of all formal foster care placements are with kinship caregivers. So going to live with kin, yes, absolutely. In general, that's way better than going to live with strangers. Certainly, way better than going to live in group homes and such. But that doesn't distinguish this from the formal foster care system, because that happens all the time in the formal foster care system too. What happens next? That's actually a really hard question to answer because we don't have good data. I'll talk about that in a minute. But when we have had studies, Texas actually had one of the more comprehensive studies a number of years ago. We know that a good portion of these kids end up coming back home to their parent, just as in the formal foster system, where we know that reunification is by far the most common outcome, and some of them don't. Some of them are not reunified within a year. Some of them end up in court later on. So on all these respects, what we're talking about looks a whole lot like the formal system. Okay, so hidden foster care system. How is this really a system? How often does this really happen? Short answer, a whole lot, right? We don't have, we'll talk about the data gaps briefly. It can't go to the Federal Children's Bureau and look up the latest AFCARS data and tell you that on September 1st of last year, there were X number of kids in hidden foster care, because agencies aren't required to report those numbers. But we know from a variety of sources that this happens with great frequency, different frequency in different jurisdictions, that's to be expected. But this happens with great frequency, I believe, on par with the formal system. You can see on the screen, Child Trends, a think tank in our field, did a close study of several urban jurisdictions around the country. They found this practice being used very frequently. They refer to it as kinship diversion. That's the other jargon you'll hear. That's the term diverted in that quote. In some jurisdictions they studied, there were 7 hidden foster care cases for every 10 formal ones. In some, it was a 1-to-1 ratio, just as many. You see the adjectives used in the social work literature. And several states, I'll show you this slide before I go into several states. This is an older study, 2008 to 2009. There's a cut and paste of the graph from that study. For our purposes, look at the dark blue versus everything else. Dark blue is what they call informal kinship care, as in hidden foster care without going through the formal court system, without calling it formal foster care, versus the light and dark green and the little bit of light blue, that's the light blue, the group homes. You can see they're roughly similar amounts of kids in that study from now 12, 13 years ago. Some states have made some data available, and when we look at those states, we again see variations from state to state, but we see that this practice happens a lot. So I start with my home state of South Carolina. This is 2018 numbers. These are a little hard to find. It was at a presentation where DSS shared the data that is on the shorter column. The left-hand side, that's the number of kids who enter the formal foster care system. On the right-hand side, that's the number of kids that South Carolina DSS claims are living with kin under a safety plan, right, in that year. So if we included them as part of the entire system, the system would grow by 50%. In Virginia, the proportions are a little different. This is there's some good local reporting and some good local advocacy that led to the revealing of these numbers. We're actually in at least 1 year, not too long ago, there were more kids that the Virginia department counted who had entered informal foster care than formal foster care. The department was actually also reasonably honest in saying that they really don't know what happens to these kids in the taller column after a period of time. They don't know how many are going home, how many are permanently separated. Apologies to Andrew and anyone else from Texas for the lame Texas joke on the top of the slide. This is from that same now slightly dated Texas study, but showing 3 times as many kids entering the informal system as the formal system there. Bottom line, this is done on a systematic scale, again, on par, I believe, with the number of kids who are brought into the formal system. So and the family separations are the same, so demands our attention. Okay, how is it hidden? How is it the hidden foster care system? Most obviously, it's hidden from all of you, and it's hidden from family court oversight, right? Because when a parent is presented with a safety plan form, they are not, in current practice at least, provided an attorney with whom they can consult, unless they are someone with means who can retain someone privately. There aren't lawyers for parents to say, hey, CPS, you ain't got the goods. You can't prove my client did this, or there's not a necessity to do this, or, okay, there may be neglect under our state's broad definition, but there's not an imminent risk of neglect. Or, you know what, you're obligated to provide reasonable efforts, and so why don't you do X, Y, and Z before you talk about separating my client and her child. And there's no lawyer to do that. There's no court that you go to where a lawyer can make all of those arguments before the court. And because the agency isn't going to court and triggering that process, its legal obligations to provide reasonable efforts to prevent the family separation, that legal obligation doesn't apply. There are no reasonable efforts then to make sure that the child, no requirement to make efforts to reunify the family after the safety plan is in place. And all the many questions that happen after a child and parent are separated. What should the visitation arrangement be like? Something has changed reasonably quickly. Can they reunify? There aren't any due process checks on any of that. It's hidden from all of that. And it's hidden from the policy or systemic oversight, right? So yesterday in his keynote, Marty says, as many of you have surely heard him say, often, we have 20,000 legal orphans who quote unquote age out every year. Well, where do we get that? We get that from the AFCARS reports that states send up to the feds and is put regularly on the Children's Bureau website, right? It's easy to find, and we can debate it and argue for policy changes based on that. But we can't do that for hidden foster care because states aren't required to report it to the feds, and each state does their own thing. I pulled some states' data, but lots of states don't have that data readily available, right? So we don't know how many kids exactly this happens to. We don't know what happens to the kids. We don't know how many return home or how quickly they return home. We don't know how many are permanently separated from their parents. We don't know how many end up being petitioned later on. We don't know the racial disparities. I think I can say with reasonable confidence that they're big, and they're probably similar, if not larger, than in the formal system. But we don't have data tracking that, and so it impedes our ability to have a strong policy conversation about it. So that's another way this practice is hidden from policy oversight. Okay. So if one of the key ways that it's hidden is hidden from court oversight, from all those due process things, all those checks and balances that we as lawyers hopefully take advantage of. What have courts said about it? And there have been some lawsuits. I'm going to give you two somewhat older cases that provide different answers. So the Third Circuit, this is actually a 1997 case, Croft versus Westmoreland County Children and Youth Services Agency. The dad was told by CPS he's got to leave the home, right? And he later sued after the case was resolved. And the agency said their defense was, well, it was voluntary. He didn't have to agree. He agreed. He signed the paper and he left the home. And the Third Circuit has the same response that I do, which is to sort of scoff at that, right? When you're faced with this threat, we're going to take your children into foster care. They can go live with strangers, right? And because any case, as we know, can lead to any disposition, and if things don't get resolved quickly, can lead to a TPR after 15 of 22 months, right? That threat is really, really powerful. It's like in a criminal context saying, well, you could agree to do this, so you person I'm accusing of shoplifting, and then go into a system, or you can go into the formal system where the capital punishment, the death penalty, is possibly at the end, as the civil death penalty, TPR, is at the end, possibly at the end of any of our cases. So they scoff at that in the language you see on the screen. A few years later, the Seventh Circuit, Judge Posner, for you federal court geeks out there, writes a very different sort of opinion. I'm going to turn it over in a couple minutes to Diane. She litigated this case and lost, and I hope I'm not re-traumatizing her with this slide. So he writes, well, if this isn't coercion, it's not an unlawful threat, it's voluntary. It's the state saying, here are your choices, here's what you're going to do. And he analogizes it to privileged people at a cocktail party choosing between a martini or a Manhattan, right? If the host tells, if you tell a guest, you'll mix him either a martini or a Manhattan, how is he worse off than you tell him you mix him a martini? In this, I think the martini is formal foster care and the Manhattan is hidden foster care. And he's envisioning a privileged host and a privileged guest at a nice cocktail party enjoying drinks, right? We know that's not how it goes down. We know there's a huge power disparity. He ignores all of that in his decision. That said, Dupuis is accepted it's still the law in the Seventh Circuit. There have been some changes, Diane will speak to that. And it's been followed in a couple of other federal circuits. So while I obviously disagree with it, I want to kind of take it as is, but go a little deeper and to talk about when there's still a due process problem, even if Dupuis applies. Because even under Dupuis, the state still has to be making a legitimate threat. If they can't prove that a parent has abused or neglected their child, if they don't have sufficient evidence, or if the evidence that they have doesn't rise to whatever abuse or neglect is defined as, or if any other element of emergency removal isn't met, right? If there's not an imminent risk, if there's not necessity, whatever else may be present in your jurisdiction, right? Then there is still a due process problem. Even Judge Posner recognized, okay, there'd be a due process problem if it was a threat the agency had no right to make. Now, can't resist this other colorful quote. It's from a law school note by a guy named Ryan Shalati about why this logic is so problematic in practice. Because again, it's not a cocktail party with privileged guests. It's someone who has the power to destroy families, and then someone without counsel trying to figure out how to navigate the situation. And as he says, they're supposed to try to figure out, the parent is supposed to figure out, is this threat legitimate or not? They're supposed to somehow know that in advance or know whether the gun is loaded or not, right? in his analogy.
Josh, can we pause for 1 minute for a few questions, if that's okay? So we had a good question that, going back to your data slide, saying that if you had a guess with regard to disproportionality, would you have kind of an educated guess? Because this person writes in that they've heard from people in some systems that it's more likely for white families and kin of white families to be trusted with an informal arrangement than non-white families, which I think is an interesting point. If you have a comment.
So I have a couple guesses. One is that it's going to vary from jurisdiction to jurisdiction. Like I think we've heard from some places, oh, they use this a lot, but during investigations, and then they stop it. Or they use this, some places will say, oh, they use this, and you can, the cases are just as severe as the ones they formally petition. It's not clear why. Or they use this in cases that they can't quite prove. Right? I suspect in some jurisdictions, the disproportionalities may be worse, as in more Black families being brought into hidden foster care, either because it's one of those cases that they don't think they can quite prove, but they got a bad feeling, whatever that bad feeling means, informed by whatever implicit biases may be there. And so I think that could play out more frequently with Black families. I think there's a lot in the literature about, the long history of kinship care within Black families. I think there may be some places where kinship care is seen as a Black thing, right? And so they may be more frequently used. Also, as I'll get to in a minute, this is also the agency taking advantage a little bit of the kinship caregivers by denying them the subsidies that would come with formal foster care. There's a trade-off there, so it's not always that simple. I suspect there are some places where they're more likely to take advantage of kinship caregivers in that way for Black families. And I'm sure there are jurisdictions that are along the lines of what the questioner said.
Yeah, and if I could just add that historically there is also a bias that families of color will not pass licensing regulations. So therefore we're going to bypass even offering them that formal foster care structure because we're going to assume that they won't pass those standards anyway. So that's kind of another layer as well.
Yeah, that uncle lives here and he might have a drug conviction from 10 years ago. And yeah, we could get a waiver, right. But yeah.
Right. We did have one other question, but I think we're going to address it later. So I want to put it out there to the panel. And please remind me if we think we'll get to it later. But in that whole definition of hidden foster care and the different ways that this can happen, Melissa wrote in that using short-term guardianship outside the system, not even entering a safety plan, but having them, and I often call that kinship diversion, of moving children into a kinship family without even a safety plan in place, is another way to kind of circumvent all the protections within the system. And she's saying in Chicago, it's often done without even a parent's signature, but that legal document can be used to show sort of this change in custody. And is that something that you think that's kind of an upcoming practice, and how you might want to address that? Is that also part of this continuum of hidden foster care?
Yeah, I think what I would say quickly is that, and I'm curious if Andrew or Diane want to weigh in, is a safety plan is not really much of a legal document, at least not a legal document in terms of changing legal custody. It doesn't purport to, it usually cannot in any state. So if there is a way to do that temporarily, like some places have custodial powers of attorney, right, which are generally better because they give parents more power and they can revoke them and that sort of thing. So that could all fall under the same heading. I will not pretend, Diane, if it's in Chicago, probably knows better about the Illinois specific practice there.
Okay, thanks, Josh. We'll let you continue.
Okay. So all under the heading of, even if we accept Dupuis, it's a legitimate threat to say, hey, sign this or we'll remove your kid, if they have the goods, if they can legitimately say, we will remove this child. Right? And that begs the question of, okay, so do we actually trust CPS agencies to get that right and to get it right consistently enough without any due process protections, without the checks and balances that come in the formal system, right? And on the screen is a short list of the questions that need to be answered correctly in that sort of situation. And I probably, at the parent representation conference, don't need to spend any more time suggesting that it's not the cute fuzzy teddy bear on the screen, that we should have some serious doubts about whether CPS agencies are, without checks and balances, actually going to get all that right. And I will turn it over to Diane, who's going to talk a little bit more about this voluntariness and due process question.
So thank you, Josh. So before I get into a little bit more about coercion and voluntariness, want to highlight the law review article that Josh wrote that is in the files. Also a law review article by Ryan Shalady is also in the files. Josh's law review article goes into beautiful and thorough depth of discussion about both Croft and Dupuy, and I think it became the background for this panel, for our work together. And so I want to highlight that before I talk in more detail myself, so that you have a resource to go to about all these cases, and you can study it a little bit more after the panel. But just to highlight some points about Dupuy, first of all, the decision itself is incredibly misleading because the district court in Dupuy found express coercion of all the plaintiffs. So express coercion was found by the district court as a matter of fact. And so Judge Posner, when he said safety plans are voluntary, was flying in the face of his own duty to defer to fact-finding by the district court. And he held it was quite a bit worse than lawful threats. I think that's been a gloss that's come after Dupuy, that you have to have a lawful threat, because the case came to Judge Posner on an appeal from the finding of the district court that mere suspicion was sufficient to demand a safety plan. That was our claim as plaintiffs. It was that, no, mere suspicion is not enough. That's like saying a hotline call is enough. Just the fact of a hotline call. And what Judge Posner said was there's nothing wrong with coercing people. And as long as you're not affirmatively misleading people. And that's where, how in the world would a parent know? You don't know what evidence has been gathered. You don't know anything. People are coming into your home, making demands that you leave or that your children leave. How do you know? And it's confidential who reported. So how do you have any idea? Josh is correct that Dupuy has been limited to this sort of lawful threat idea. And subsequently, after the Dupuy decision came down, as the lawyers who had spent already 8 years by that point, and it was another 5 before the case got fully resolved, what would we do in the face of this horrible decision by Judge Posner, other than talk to Josh and get him to write a law review article 15 years later? I mean, that's one of the things I think that we did end up, having some influence indirectly. So what did we do is, first of all, we mounted a huge effort to try to get the Supreme Court to overturn it. And we had brilliant legal help. We had the Stanford Supreme Court clinic, and it was turned down, unfortunately. So we were stuck. And some of the ways that we tried to undermine Dupuy included trying to present a context where the threats were so obviously coercive that it would be clear that violated due process. So we had a case called Hernandez, and that case basically, I'll come back to Hernandez in a second. In Dupuy, just one second, I just need to get my own vision of the slides because they're excuse me for 1 second. I had pulled this up and I'm not able to see the slides, and I had pulled them up for myself. There we go. Sorry about that. So in Dupuy, the district court, as I said, found that everyone had been actually threatened. And the Seventh Circuit said, well, parents just have to call the state's bluff. No parent had ever done so. So this was a deep misunderstanding of the power system that's operative in the child welfare context. So we can go to the next slide. And the assumption was made by the Seventh Circuit, and I think it's commonplace, and you'll hear this language, and as we're talking about language mattering at this conference, you will hear this statement, it was voluntary. Things will be labeled as voluntary. This will be labeled as the parent agreed. This will be labeled as kinship diversion. You need to scrutinize that. You need to look at those words, that word voluntariness. Why does it matter? It matters because voluntariness operates as a waiver of the right. Now, constitutional rights, your right to live with your family, is something fundamental, but it can be waived. So if you were to say, I really want my child to go to grandma. I was planning to send child to grandma this week anyway. Now that you're asking me, yeah, sure, that's fine. It was fine with me. And that was just, something that I really would have wanted her to go to grandma anyway. Well, that person would have a hard time saying their fundamental rights were violated when they signed this agreement. And we as lawyers must acknowledge that if an action is truly voluntary and knowing and intelligent, then it does waive constitutional rights. But this all begs the question, because there is no process by which we can assess the voluntariness of these supposed agreements. And only in the very narrowest sense is this decision voluntary. It's like giving money to a robber and then saying it was a gift because they pegged a gun to your head. That's as voluntary as safety plans. This is why do we admonish parents when they are waiving their rights? Because we need to assure ourselves that this was a voluntary decision, that threats were not made, and that false promises were not made either in the process. So we need formal process here. If we were to do a genuine assessment of voluntariness, let me go to the next slide, we see that a true assessment of voluntariness includes a consideration of many, many factors. The notion that you can decide that something is a voluntary as a matter of law because somebody signed a piece of paper, or maybe they didn't even, maybe they left the house, as was common in Dupuy. People were ordered to leave and no signatures filed, but acquiescence was treated as agreement. If we were to do a real assessment of the totality of the circumstances, we would find that there's not a bit of indicia of voluntariness in the safety plan, hidden foster care, protective plan, whatever you call it, setting in which these separations are occurring. The forum for voluntariness would provide a way of seeing what were the circumstances of the agreement. If there were a forum for assessing voluntariness, there could be a way of appointing counsel. So I just want to stress that as you're looking into in your jurisdiction, whether you have hidden foster care and you see something labeled as a voluntary agreement, ask questions. Post Dupuy, we're on the next slide. There have been a number of cases that have cut back. I was starting to talk about the Hernandez case because that was the one that was most immediately following the Dupuy case in the Seventh Circuit, and it did set some good law that cuts back somewhat on the holding of Dupuy. Hernandez involved a child who had fallen out of his crib, we believe, and broken his leg. The state took protective custody of the child, but the case fell apart quickly. The doctor said no, it wasn't a likely child abuse case at all. And the state's attorney took a look at the evidence when the state came before it, as it was required to do, having taken formal protective custody, and the state declined to prosecute. So instead of returning the child home, though, the caseworker demanded a safety plan and said that the parents would not have the right to see their child unless they agreed, unless they signed that agreement. So that safety plan, despite the Posner decision saying all safety plans are voluntary no matter what, this one was not, because this was a demand that the parents would have negative consequences. They couldn't just call the bluff. They couldn't just call the bluff of the state and refuse it because they wouldn't see their child. The state effectively had their child. So following that, there were a number of other cases that cut back. There was a trilogy of cases in Illinois that took on different contexts: the context of a child held at the hospital, the context of a mother fleeing domestic violence and being told that she had no choice but to give the children to her abuser's family, a mother who was told she had to go into inpatient psychiatric care for a disorder that she did not have. This was a trilogy of cases, all settled with policy commitments to that safety plans are only supposed to last 10 days, that they should only be done in cases of imminent danger. Of course, making the state do all these things is not an easy task, but these are the commitments that Illinois made, even in the wake of Dupuy, following these subsequent cases. The very good news, just about 2 weeks ago, in the Sixth Circuit, there was a huge new decision, a jury verdict, which basically reinforced the idea that baseless threats are not okay, and that the claim of voluntariness is a bunch of hot air in that particular case. In that case, the facts in the case established that a father who was unable to read signed a safety prevention plan that prevented the plaintiffs from being alone with the children. And this was an in-home safety plan, not a separation, but the round-the-clock supervision of the parent was required. There was a $4.3 million verdict issued by the jury within a matter of hours, because, and the state in that case testified that they used hidden foster care agreements on, quote, stuck cases, including instances when social workers could not convince a judge to issue an order to separate the children. So in other words, this was a rampant practice, and this was policy, and this was what they did when they knew they couldn't get court orders.
We have a question about a case, and I'm not sure if it might be one of the cases that you were referring to, but someone wrote in that Walsh versus Lake Erie Department of Job and Family Services found that coercion by bringing the police, which is lawful, could violate a parent's constitutional right, and resulted in the 1983 action where qualified immunity. So qualified immunity was not able to be used, and they were wondering if that could help overturn Dupuy.
Absolutely. It sounds, I actually is not one of the cases, and I'm delighted to hear about it. So
Great.
please, if you have a site, or we'll look into it and start to use it. Absolutely.
Thank you. And there is one other question that's sort of a follow-up to an earlier question, and that is, and it comes to some of the practice used in Illinois, is based on litigation that was done, that there are more protections in place for safety plans. That whole, as I said earlier, the shift to the use of these temporary guardianships without a parent's signature, and thoughts about how to sort of combat that. And what I will say is perhaps we can save an answer and just to think about that as a panel for our later discussion about solutions, because I think what that person is alluding to is kind of other vehicles people are using because safety plans actually are generally written and have more information in them versus just shifting to this kind of other alternative custody or guardianship to a relative.
Yeah, I mean, this is a big discussion. What we're seeing in California is that they do have some more formal, but quote unquote voluntary. And then as soon as they institutionalize, the state gets around it by doing even more informal systems. I think there may be a panoply of solutions to the guardianship workaround that the states are using that need to be discussed, because once you're in court, the parent should be notified. The parent should be able to come forward and say, you know, and if we had appointed counsel in those cases, we would be in a different situation.
That's right. Okay. Thank you. And just so you know, the folks were kind enough to put some links in the chat to those cases. I'll copy them and save them for you, Diane, because it might be hard to do for you as a panelist. Thank you, everybody, and I will let you get back on track. Thank you.
I think we're done with my section and we're ready to go back to Josh.
Okay. So I can't help but say, preview to our solution section. So early in those cases, we'll talk about that more later. I'm going to talk a little bit about why this happens, right? Why does a CPS agency use this practice? If they really think the child and parent needs to be separated, why don't they go to court, right? One answer, I think I've already implied, and Diane has put even more bluntly, there are situations where they're doing it explicitly to avoid the due process protections that you all and the court system provide, right? That the testimony in that, it was a Cherokee County, North Carolina case that I think Diane was speaking about, from caseworkers who said, well, we did this in our stuck cases that we couldn't prove, right? That's why we avoided the court system, because we're avoiding due process. So that's hopefully obvious. Another reason, as I label it part one, we can think of it as reason number two. They're doing foster care on the cheap. Right? And Marty yesterday in his plenary alluded to how kinship caregivers can get less financial support from the state than strangers, stranger foster parents. And it's through this process, is because agencies save their own money by using hidden foster care. They don't have to pay those monthly subsidies that can be quite generous, $800, $900 more dollars per month, depending on what jurisdiction. And I won't go through all the other costs that are saved, but agencies do save a lot of money. Bringing a child into foster care is expensive to the state. If they can separate the parent and child, they can do it. If they can do it through the hidden system, they're going to save a lot of money. So avoid due process, avoid spending a lot of money. Avoiding spending money, that's been litigated. This is a Supreme Court case from 1979, Miller versus Yocom, where the Supreme Court held, hey, you can't screw the kinship caregivers. If you're calling them foster parents, the fact that they're kin doesn't entitle you, state agency, to pay them a lower subsidy. The Supreme Court's held that, right? So what's the incentive? The incentive is, well, if we bring them into the formal system, Miller will apply and we'll have to pay him a subsidy. We can't cheapen it too much. So again, that strengthens good decision that has the perverse impact of incentivizing states to use the hidden system more. I'd also emphasize the due process language that's bolded at the bottom of the screen, because I think that dicta is applicable here, right? Congress meant to protect from unnecessary removal all children, regardless of whether they're placed with kin or not. So don't tell me, oh, well, they're just placed with grandma, it's really not that bad. No, you're coercively separating parent and child, and that's going to cause real harm, real risks to the child. Okay, third reason that state agencies do this. It's all the vogue these days, both specific to Family First, which you see on your screen, and more generally, to try to keep foster care numbers down, right? And there's a tension here about how we do it. Are we trying to just prevent foster care or the formal foster care placements, or are we trying to prevent family or parent-child separation? So you see, I chose to quote some language from Family First and the administrative documents to show this tension. So right after Family First was passed, Children's Bureau issued that one of their guidance documents, a program instruction, saying the goal is that let's prevent those separations, right? Because we know any separation is going to come with some trauma to the child. That's what we want to avoid. That should be, I think, the answer. But the statutory text is a little harder because the statutory text talks more about preventing foster care, right? We define candidates as kids who are at risk of entering foster care, not at risk of a separation. And it explicitly talks about kids who can stay safe through a kinship placement. And so there's a risk that agencies, as they implement Family First, will start using this practice more to both to access the flexibility and funding that Family First can provide somewhat at least, and also more generally to say, hey, look, we're reducing our foster care roles. Aren't we doing a good job? Okay, what's the impact? I think I've hit all of these points except perhaps the last couple. So I won't repeat the ones I've already hit. Families are often left with an unclear custody situation, right? If the so-called child advocates were here, this is what they'd be emphasizing, right? Parents can walk through those safety plans and take the kid, and if it's one of those rare cases where there are real immediate danger, then the safety plan's not actually doing much protection. And more broadly, safety plans, because they don't change legal custody, they don't clarify legal custody, it leaves a lot of ambiguity for the family, which can sometimes lead to more conflict. And there can be some benefit, right? There are lots of families who would prefer to have the agency and the court system out of their life, even with all of the harms listed, which is where counsel and true voluntariness comes into play, so that this practice is truly chosen by families, not imposed upon them by agencies. And so I think with that, I'm going to shift to Heidi, who's going to lead us in a conversation about how can we address this both in court and out of court, policy level, on an individual case level.
Great. Thank you, Josh and Diane. Much appreciated for that incredibly thorough context. So now we'd like to really turn our attention to what are the solutions and how we can address this. And for that, I think we have kind of structured a bit of a moderated panel, giving everybody sort of an opportunity to talk about potential solutions. Some of you alluded to that already in the questions in the chat, so a little preview of coming attractions. So my first question, and I think we've addressed some of this, but just to kind of reiterate, how do you know if you have a case of hidden foster care, Andrew? Because as we see, it's different in every state.
Right, and happy to talk about the solutions, and that's kind of where I'm going to do the bulk of the lifting, because that's what I get paid to do. But how do you know if you have this case of hidden foster care? Generally speaking, you're going to see services or restrictions put into place without court involvement. That's kind of your big 30,000-foot umbrella level. It's going to probably happen before you're even involved in the case. Generally will occur early in the investigative process. You'll either get a call from a parent or you'll be appointed, and then you'll have to figure out what's happened up until the point that you've called me. So to get more specific, it's kind of a look, listen, do. Look for kids who go to live with friends or relatives. Look for a parent who agrees to leave the home for a period of time. Signed agreements with the department or with the caseworker themselves. One thing that I really wanted to emphasize, because we talked a lot in the earlier part of this panel about the separations, the kinship placements being a very common form of hidden foster care. Hidden foster care can occur without that child leaving the home. So look for a friend or a relative that's suddenly staying in the home. So sometimes you'll have the children not being removed, but the family will agree to having a third party come and live with them and supervise them 24/7 when they're with their children. So a removal of a child or the child going somewhere else is not always there, but you can still have hidden foster care. And then look for indefinite time periods on these arrangements. Because these agreements are in place, and if you look back at the Texas form that's in the files document of this panel, you'll see that your caseworker will notify you when these restrictions can be lifted and when these have been satisfied. It really is left in a lot of places in the judgment of the department. In Texas, we've had a few cases where it's been referred to as the department's unbridled discretion to hold families under their surveillance and under their authority without any type of accountability. So they're able to move goalposts on families, such as changing the terms of the agreement by not having any type of time limit. As I said earlier, these families can pretty much languish in these arrangements for indefinite periods of time. And then the due aspect of it, right at the beginning, get copies of documentation that was given to your client, call that caseworker immediately, notify them that you're representing the family, ask for the allegations. Remember, federal law requires allegations to be revealed at first contact. That includes with you representing the family. Get those allegations within the first few minutes of your phone calls. Diane or Josh, anything that you would add to that kind of that do section?
Diane, you're on mute, and I think we're going to hear from Diane about kind of how to handle it in court. So I think the question is really identifying hidden foster care, and it sounds like from what Andrew said, if you think it is, it probably is. So yeah, Josh and Diane, if you want to add anything else.
Yeah, I am going to talk you have a question, I think, that's going to come to me. But I want to, I want to highlight that one of the handouts is on identifying. We have a form in the file on how to identify. And certainly it's looking at the forms, it's talking to your clients, it's all the understanding, how did they get to this point? And what's their understanding of what would happen if they were to change that? Who's going to complain? What's going to happen? What are the consequences if they don't follow what they understand to be a certain restriction on them?
Anything you want to
add? Not now.
Okay. And I just wanted to reiterate, Andrew said, going to live with a relative or relative coming into the home is certainly a clue with some sort of agency intervention that has resulted in that, because we know this parent using relatives to help them out happens without the agency being involved or aware at all. And that's not really hidden foster care. That's really just what we call an informal system that happens naturally. So I think, to reiterate Andrew's point, living with a relative with some sort of agency involvement and intervention that has prompted that arrangement. So excellent. Okay, so next question. Family defenders may not encounter hidden foster care until well after it happens, when the state later files a petition on the case. Diane, what should the defender team do in court if they are experiencing this hidden foster care for their clients?
So step one is look into it, whether it's happened. You need to ask about the dates of the separation. How long has the child been separated from you? If the child was just taken into protective custody, that is probably less likely to be a hidden foster care case. But if the child has been separated or under restrictions, then you know that this has gone on for a while, and you need to find out the circumstances of all of that before you even begin to fight the temporary custody or seek the return home. So how egregious was the threat, and how long did this go on, and how baseless? It might tell you something about the strategies you're going to be developing in the case and what you present in court. But at a minimum, you can use the information about what happened during hidden foster care to affect the case for removal right now. Use the information to challenge the lack of reasonable efforts, and develop a record for your client's compliance and the lack of appropriate services. So I worked on, for this panel, a document, which is also in the files. I'm the one calling all the attention to the materials. And I want to thank Sylvia Long, who's in the audience, for giving me the kind of framework for using this in court, which she did. And it's a case that's actually, I understand, to be pending in the appellate court right now. So that's the other thing, is to use these materials and these lines of argument to build your record, because even if you don't succeed in your particular case, you may help to build a record against the practice down the road. So in the outline for strategic use of lines of cross-examination, there are basically different things you can bring out about hidden foster care in your court action. First of all, you can challenge the caseworker's authority to remove the child without seeking court intervention. Sometimes judges do not take so kindly to that. And related to that, you could show that the arrangements that they've been living under were not voluntary. You can go into the question of the family's access to the child during periods of hidden foster care and use that to support more visitation. You can use the period of hidden foster care to show why the child is safe and can be returned home. Obviously, the state didn't think it was a serious danger enough to petition the court, so you can use that. And again, lack of reasonable efforts, because there was a period of time when the state was, should have provided alternative services and failed to do so. And now they're coming in later and claiming they made reasonable efforts when they probably didn't. So if you look at those, that document, you'll see a series of questions under each of those headings that you can consult. Obviously, judges are not probably at a temporary custody hearing going to let you ask every single question, but at least you'll be able to have a framework to tailor it. The second thing is, if you see it, there's a potential for affirmative litigation. We've talked about some cases that have been lawsuits, and there are some handouts about that as well. If your case ends up not being substantiated, if the case gets dismissed in court and the child was separated under a hidden foster care, that is potentially a 1983 case, and you should consult those handouts and figure out how to advise your client about that. So those are some ways family defenders can raise this issue when they see it.
Great. Thank you, Diane. Josh and Andrew, anything you want to add to the litigation end of things?
I'll add one thing. Ryan Shalatti's law review article, which is also in the files, compiles state administrative agency policies. They, of course, can change at any moment, so your current state one. It's worth becoming familiar with your jurisdiction's policies. You probably know that agencies don't always follow their own policies, but if they have policies on hidden foster care, they're worth knowing, because some of them will include things like time limits that the state may just blow through, or maybe they're right up on the time limit and that's why they're petitioning the case. Either way, that's worth knowing, and this is one example of what being familiar with the policies can, the way it can inform your advocacy in an individual case.
Thank you. Andrew, anything you want to add before we move over to policy? That was a good segue. So my next question is, what are some potential policy solutions if you're in a state that doesn't have policy or has bad policy? What steps can be taken to implement these ideas, these policy solutions, Andrew?
Yeah, and there's a number of things that can be done, and there's things that we are doing right now in Texas that I've linked to in the files documents, and I'll be addressing a little bit later on. But first and foremost, as Josh alluded to earlier appointment of counsel. This really is key to putting the brakes on hidden foster care, having you all early in the process involved and advocating for your clients. And we now have the tool to do it. The Children's Bureau allows Title IV funds, as you all know, to appoint counsel for parents. Now, back in June of last year, then President Trump signed Executive Order 13930. And one of the things in this large executive order, and I looked it up yesterday, it has not been rescinded by the Biden administration, so it is still on the books. It directed HHS to provide guidance to states regarding the use of federal funds to provide pre-petition representation for families involved with CPS. In response, the Children's Bureau issued that guidance document in the form of informational memorandum. It's IM 21-06, also linked in the documents if you want to take a look at it. That came out January 14th of this year, and it clarified that indeed Title IV funds are now available to provide legal representation for foster care candidates and or their parents, including appointment prior to filing of a petition to remove the child. Now, states are trying to figure out how do we actually implement this. So for example, in Texas, our Department of Family and Protective Services is the Title IV agency for this purpose. However, when council is appointed, it's appointed by the counties. And so what we're trying to figure out is, okay, how do you do that pass through? Because the counties don't want to be on the hook for money that's being given to the state that they're having to spend. And so we're trying to figure out, okay, how do you make sure that that drawdown actually gets to the counties that are appointing the attorneys earlier on in the process? So get involved with your state, figure out either the department or the legislature to figure out, is there a mechanism in place to draw down those Title IV funds for this purpose? And if not, be a part of the group that tries to figure out how to do that. In our own experience, our Supreme Court has a commission that's specifically focused on child welfare issues, and they will convene work groups fairly frequently to solve these problems. You know, figure out if your state has something like that. Figure out how do you get on the work group that makes the proposals for implementing these new policies. The other piece of this is requiring due process and court oversight for these arrangements. Now, one thing we always need to remember that not every case needs to be in the foster care system, but there always needs to be limits and oversight, especially oversight of the department. So things that we've talked about already, those time limits. How long can a family be under a safety plan? How long can a child be in a voluntary kinship placement before something else has to happen? You know, whether things get alleviated or if it gets to this point, hey, department, you've got to put your money where your mouth is and plead this thing and see if a court will back you up. Specify the required services. And this is something that I really want to emphasize because in a lot of cases, the department is the one that specifies the services. There is no requirement. It can be whatever the department thinks it needs to be. This is where they can move the goalposts on families, where they can say, well, you need to address these things, and then come back later and say, you didn't quite do that well enough. We also need you to do these things. And if there's no independent oversight, if there's no guardrails around that, you can have situations where families just are perpetually in this cycle. So ensuring that there is law and legislation on the books that can put those limits around that. And then, of course, having a court order in place. And how do we do this? We want to research our state statutes that authorize hidden foster care. And it goes by a lot of different names. Two examples of programs that we have here in Texas that are part of the broader umbrella of hidden foster care are family-based safety services and parental child safety placements. And these are specifically authorized by code. We also have things called prevention and early intervention services. Lots of fancy terms will be thrown around, so you actually have to see where they're authorized and what parameters actually exist in the statutory authorization. And then once you've identified those problem statutes, you can then get to work with your legislators to start pushing to make changes on the policy end of the spectrum. And a few recent examples that we've been involved with that I've linked to in the documents as well. Two have passed. One, unfortunately, didn't make it across the line this session. But within House Bill 567, this one will be effective on September 1st here in Texas. It was kind of an omnibus CPS reform package. So there's a lot in there that's not really related to hidden foster care, but feel free to dig into it if you're interested in the legislative solution side for CPS reform. And you can reach out, email me, call me. I'm happy to talk with you about this piece of legislation and the different components of it. But the key point for the purposes of our discussion is that House Bill 567 amended Texas code that allowed courts to order families to participate in services requested by the department. And within that code, we inserted a full slate of due process protections requiring a hearing. Now, if you are curious, you can go back and look at the code as it is right now before the amendments go into effect. And it's a very, very short bit of code. It's 264.203 of the Texas Family Code. And it essentially says, and I'm paraphrasing, that the court may order whatever services the department requests to alleviate the danger. Full stop. And there's been a little bit of litigation around this at the district court level. And what judges have said is this amounts to giving the department unbridled discretion to regulate a family. Essentially, the court can order you to do whatever the department tells you to do for as long as the department tells you to do it. And then if you don't do it, they can remove your children and potentially terminate your rights. Massive, massive problem. We argue that it's unconstitutional and haven't gotten the ability yet to get to the point where we can make the constitutionality argument in front of the state Supreme Court. However, the amendment to this law that will be in effect in September requires that full hearing on the requested services by the department. It also requires the courts to enter a written order identifying the specific services that are required of the family. And then it goes a step further and requires that those specific services that are ordered must be narrowly tailored to address the specific identified risk. And I think these are key elements when we're looking at how do we change hidden foster care. We want specificity in the orders. We want oversight. And we want the services to be narrowly tailored to identify any risk that may or may not, that may exist. If it doesn't exist, then we shouldn't have it. Another piece of legislation to draw your attention to, House Bill 2680, that would have set a 30-day time limit on all parental child safety placements in Texas and required the department to notify parents of their right to refuse to enter into the agreement and be represented by an attorney before signing. Unfortunately, due to the timelines that we have to work with in Texas, it did not make it all the way across the line, but it's gotten the conversation started. And again, that's something I'll get into just a little bit later. Getting that conversation started around hidden foster care. I mean, we saw from the poll at the top of this panel, more than half of you all, this is new to you. I can guarantee you it's new to most members of your state legislatures. And so there's an educational element that has to be done before meaningful change can happen. The final piece that I want to point out is House Bill 3041. And this was our plan for implementing the Family First Prevention Services Act. A couple key elements of this provision is requiring a hearing and oversight of any prevention and preservation services. It's passed both chambers. We're waiting on the governor to sign it. But that kind of allows me to shift into the importance of Family First and family advocates being involved with Family First implementation. And this is really kind of where the rubber is going to meet the road, because Family First can either formalize and give more credibility to hidden foster care, or it can be used to rein it in. One of the key pieces that your states will have influence over that you all should be involved with is defining child who is a candidate for foster care. Family First left that definition to the states to determine what that means. That was the big thrust of what we were trying to do with House Bill 3041 in implementing Family First, is controlling that definition. And we crafted the definition with our legislative sponsors in such a way that it really is focused on that child who, but for the prevention and family preservation services, would have entered the foster care system. You know, the argument there being, if you cast this net as wide as possible, we're not actually going to know if Family First worked at preventing kids from going into foster care if we're pulling in people who didn't need to be there in the first place. So really restricting that definition and making sure that that's targeted those kids that, you know, we are pretty certain we're going to go into foster care unless we did something else. That's going to be a major way that you can really restrict some of the damage that could be done through Family First implementation. The other piece, the due process protections that we've been talking about, and you know, that's the drum we're hitting over and over again. Make sure those protections are involved in prevention and preservation services. You know, make sure that there's court oversight. Make sure that the services are narrowly tailored to address the specific risks identified. Make sure that the department has to actually plead the allegations with specificity when they are seeking prevention and preservation services. You know, these are little guardrails that you can put in place right now. I think most states are shooting up on the October deadline for implementation. So there's work going on right now. If you're not involved with it, get involved with it, be at the table. Because if you're not, then family defenders are going to get railroaded in the process. Not to be too negative about that. A few other items to look for with policy, data tracking. Federal law currently does not require states to provide data on the hidden foster care arrangements. States are free to track this data on their own. It's how, you know, Josh was able to get at least somewhat of a thumbnail sketch of what it looks like in South Carolina and Texas and a few other states. So start checking to see if your department is tracking this data or at least publishing it. I can guarantee you they're tracking it. If you don't see it published anywhere, see if the department's willing to start publishing it and reporting on it. If not, now this is where I think the better solution is: work with your legislature to pass legislation that actually requires that the department to publish that data. I wasn't able to get it into the documents for this conversation. There is a data bill that we're working on in Texas, Senate Bill 1079. If you want to look that up, it's still in process of being negotiated, so I didn't have final language yet. But one of the pieces that is in part of that negotiation process of being inserted into what are we requiring the department to report on a monthly basis are hidden foster care arrangements using the terms of art that we use in Texas code. And then finally, you know, the big thing, due process, due process, due process. So when you're analyzing your state's hidden foster care system to look for areas to make changes in policy, we're looking for things like pre-petition representation for parents, written notice of the grounds for entering into the foster care arrangement, those allegations that we talked about earlier. What's the standard for intervention? Is it imminent risk of harm? Is it immediate danger? Is it some type of suspicion? Look for, are there time limits on plans, or is this an open-ended as well as with the service requirements? Are these a narrowly tailored service requirements that have to be targeted, or are they open-ended service requirements? Is there any form of court oversight? Is there a mechanism to challenge the safety plan? And then a requirement for the department to disclose reasonable efforts taken to prevent the removal, or for the courts to later identify what efforts that they found reasonable. Again, coming back to this idea that if we are going to get in some type of an arrangement where we are ostensibly trying to avoid foster care, what we're doing needs to be reasonable. And having that documentation, requiring the department to actually document it and be accountable for that before a court, is a major, major change that many states can make in their statutes.
Thank you, Andrew. Well, sadly, we are running out of time. So I know that there are a few areas we did not get to address. Josh, can I just ask you for a quick update on sort of federal efforts and media attention? Those are the two things I think we did not address out of everything that we had planned to continue saying. So Josh, could you hit those two if you don't mind?
Yeah, sure. So there's been an increased amount of media attention to this. The imprints run a number of stories. There's been a number of local newspapers that have run stories on this. And it's really intriguing. Press has been intrigued by this. So if you are inclined, especially if you have a client who is willing and is in their interest to speak publicly, it may be worth calling your local reporter or at least thinking about that. because that starts the conversation, gets a lot of attention, and can start the ball rolling. In terms of federal attention, there's been a group of us, we put, who kind of created an ad hoc work group under the auspices of UFA, United Family Advocates, which Diane leads and Andrew is a co-chair of. We have a letter that we sent to the newly Children's Bureau that's in the files. We hope to have some sense of what they think about that in short order. And I'm superstitious enough to stop talking.
Thank you. And thank you to all the panelists for this great discussion. I know that Diane was going to open up a group room for anybody who wants to hear more and wants to have a conversation, and you'll be able to speak in that group room. She's going to open up a group room for further conversation. And I would just encourage you all to look at the great handouts that are in the files section. So thank you very much to our panelists, and apologize that we ran out of time to cover everything, but we came really close. So excellent. Thank you everybody for attending, and great questions. And yes, that is a Twitter hashtag, #ParentRep21 for the entire conference.